Welcome to Spoken Injustice, where we put the criminal justice system in the dock. In today's video, we're going to look at the public inquiry recently announced into the events surrounding the deaths and near deaths of several babies at the Countess of Chester Hospital, which a criminal trial determined to be murders and attempted murders committed by Lucy Letby. First and foremost, I wanted to highlight that by discussing this matter, we do not wish to cause any distress to parents and families impacted by the events which are concerned with this inquiry and to whom we send our deepest sympathy. We will aim to examine first the timeline surrounding the announcement of the inquiry, then the scope of the inquiry, and finally we will provide some questions for discussions. So follow us until the end. Let's start with the timeline. On the 18th of August 2023, the Department of Health and Social Care announced an inquiry into the circumstances behind murders and attempted murders of babies at Countess of Chester Hospital to help families get the answers they need. On the 30th of August 2023, Health and Social Care Secretary Steve Barclay announced that the inquiry into the circumstances around crimes committed by Lucy Letby will become statutory. We have discussed the difference between statutory and non-statutory inquiry in our video news session, Inquiry into Mr. Markinson's Wrongful Conviction, which you can find linked in the description below. It suffices to say here that the main difference is that statutory inquiry has additional power to compel witnesses to attend hearings and or give evidence to the inquiry under oath. Going back to the announcement of the 30th of August, the government indicated that it will look to appoint a judge to chair the inquiry and that will publish the inquiry's terms of reference, setting out the scope of the work in due course. On the 4th of September 2023, making a statement to the House of Commons, the Health Secretary announced that Lady Justice Thirlwall, senior judge and barrister, will lead the inquiry. As per the scope, he said, this inquiry will examine the case's wider circumstances, including the trust response to clinicians who raised the alarm and the conduct of the wider NHS and its regulators. On the 19th of October 2023, the government issued the terms of reference in a press release in which it is stated that the terms of reference are set by the Health and Social Care Secretary after consultation with the chair, who is engaged with the families and other stakeholders. Now, before we go into the details about the terms of reference of the inquiry, here are my usual reminders to like this video and subscribe to our channel if you want us to continue raising awareness of the often neglected issue of wrongful convictions. Back to the terms of reference, the inquiry will cover three broad areas: the experiences of the parents of the babies named in the indictment, the conduct of clinical and non-clinical staff and management, as well as governance and escalation processes in relation to concerns being raised about Letby and whether these structures contributed to the failure to protect babies from hair. The effectiveness of the governance, external scrutiny, and professional regulation in keeping babies in hospitals safe, including consideration of NHS culture. It will not review the jury's verdicts and will make no findings regarding liability in civil proceedings. The last statement appears troubling to those who were hoping that the inquiry would have gone beyond the findings of the criminal court. So the question for discussion here is, should the inquiry have prescinded from the findings of the criminal court in the case of Lucy Letby and start from a point where the deaths were looked initially as deaths rather than murders in order to establish where these were in fact as a result of foul play? And if indeed as a result of foul play, was this of a criminal nature or medical malpractice? There are several reasons which may justify the inquiry to prescind from findings of the criminal court. First, on the 15th of September 2023, it was announced that Lucy Letby formally lodged a bid to challenge her convictions at the Court of Appeal. This means that Lucy Letby's legal representatives have prepared grounds of appeal arguing the safety of her convictions. A factor that the inquiry is astonishingly completely ignored. And is this a reflection of a generalized view that appeals are there just so that justice can be seen to be done, rather than concrete means to correct errors? Secondly, what if, and we are not saying this is the case here, as we have no direct knowledge of the facts, but what if medical malpractice was a contributing factor? Wouldn't this make it easier for those involved to just sweep any malpractice issue under the carpet and hide them behind the murderous actions of an individual? Thirdly, and perhaps more poignantly, we have already mentioned the growing concerns from leading voices in the scientific community in relation to evidence presented in the Letby case in our video Letby and Brand Media Feeding Frenzy Meets Contempt, which you can find linked in the description below. We have also previously referred to a report issued by the Royal Statistical Society in November 2022, raising concerns on statistical evidence used in healthcare serial killers cases in our video Criminal Evidence Roulette, The Risk of Statistics, which you can also find linked in the description below. As a lawyer and as a secondary victim of a wrongful conviction, I know too well how the criminal justice system is fallible. Indeed, the fact that there is an appeal procedure acknowledges this fallibility. In his final report on access to justice, Lord Woolf wrote that there are two main purposes of appeals. The first is the private one of doing justice in individual cases by correcting wrong decisions. The second is the public one of engendering public confidence in the administration of justice by making those corrections and in clarifying and developing the law. As we know, in criminal trials, juries and judges are bound to decide on the facts presented at court and cannot go beyond these facts. On the other hand, inquiries are based on a principle of independence, openness, and transparency aimed at finding what actually really happened, who is responsible, and how lessons can be learned so that those events do not occur again. The function of a public inquiry, unlike that of a criminal trial, is primarily inquisitorial. The role of the inquiry chair is to gather information and make recommendations rather than responding to specific complaints. In light of this, could it be argued that if this inquiry is to be an effective and independent one from which the truth must come out so that real lessons can be learned, then shouldn't have been proper and fair to be treated and run independently from the findings of the criminal court, greatly limited by the strict adversarial and evidential rules? In December 2017, the Institute for Government published a report entitled How Public Inquiries Can Lead to Change. The report states there is an expectation that inquiries will answer at least 3 questions: what happened, who is responsible, and what can we learn from this? This report also highlights the importance of the use of experts, stressing that inquiries should make more systematic use of expert witnesses, potentially via seminars at an early stage, to bring the inquiry panel up to speed on key issues. At page 5, the report states, to develop robust, implementable recommendations, expertise on the issues at hand is needed. For instance, specialist knowledge of the intricacies of child heart surgery or fire safety during building construction, or an understanding of the information sharing practices of different public services. Additionally, knowledge on how to construct policy recommendations in a form that is likely to have traction in government is an aid to effectiveness. It is not realistic to expect inquiry chairs to possess all these skills or knowledge. Therefore, inquiries should adopt a seminar process to involve expert witnesses when developing recommendations. It is in this context that on the 29th of September 2023, the Royal Statistical Society, or RSS for short, wrote a letter to Lady Justice Thirlwall. The letter was signed by Dr. Andrew Garrett, the president of the RSS, and Sarah Chambers, its chief executive. The letter states, our understanding is that your inquiry will focus on the wider circumstances of the case. Some of the evidence used in the trial was, on the face of it, statistical in nature. For example, the duty roster spreadsheet of data that indicated Lucy Letby's presence on shift when babies collapsed or died. And if you are considering ways in which NHS trusts might more quickly act in this type of case, evidence based on statistics and data could well play an important role. However, it is far from straightforward to draw conclusions from suspicious clusters of deaths in a hospital setting. It is a statistical challenge to distinguish event clusters that arise from criminal acts from those that arise coincidentally from other factors, even if the data in question was collected with rigor. This is an area where the Royal Statistical Society has recently conducted work. In 2022, we released our report, Healthcare Serial Killer or Coincidence? Statistical Issues in the Investigation of Suspected Medical Misconduct, which details some of the challenges in using statistics and data to identify criminal activity in a medical setting and set out some proposals for how statistics might be properly used. We are writing to propose that you consider including a point in the terms of reference for the inquiry on the appropriate use of statistical evidence in this type of case. Statistical evidence is one type of evidence the NHS trusts might use to identify criminal activity, and it is important that the right lessons are learned and that it is used appropriately. The Royal Statistical Society will be pleased to support you through. It is clear from the terms of reference now published and a lack of response to this letter, or at least we could not find one in the public domain, that the RSS will not be involved in the inquiry. In conclusion, whilst the principles of judicial authority, integrity of the criminal justice system, and finality may have some merits, these cannot be above the general and overarching interest of justice. Wouldn't bereaved families be best served by an open, thorough, and far-reaching investigation that prescinds from the finding in the criminal court, rather than being at risk one day, perhaps in 10 years' time, to open a newspaper to find out that the Criminal Cases Review Commission has announced the referral of the Letby case to the Court of Appeal, and the Court of Appeal is presented with new evidence which remain hidden, notwithstanding a trial, an appeal, and an inquiry? Have we not learned from history? The case of Sally Clark comes to mind. We are not suggesting that this is the case here, as we have no direct knowledge to speculate, but we have no reason to doubt the concerns expressed by the Royal Statistical Society. In its About History page, this is how the RSS is described. The Society has a long and distinguished history as one of the prominent statistical organizations in the world. From its beginnings in 1834 to the current day, we have made sure statistics continues to be promoted and applied for the public good. We cannot see a reason as to why the RSS would want to depart from this stated mission on this occasion. I hope you have found this video interesting, and if so, please like it and subscribe to our channel to join in the discussion. Also, join our networking hub at spokeninjustice.net to have your say as to the future content of this channel. Join us again next week. We look forward to usher you as we sit and rise in this unique trial.